In 1066, on the southern coast of England, a chain of events began that would eventually change how power itself was restrained. In September of that year, William, Duke of Normandy, landed at Pevensey, in present-day East Sussex. On October 14th, 1066, his army defeated King Harold Godwinson near Hastings. By Christmas Day, William was crowned King of England at Westminster Abbey. England already possessed law. Justice was administered through shire courts and hundred courts, relying on local custom, oaths, and communal judgment. Law varied from place to place. Enforcement depended on personal authority and local loyalty. William did not abolish this system, but he subordinated it. All land was declared ultimately held from the crown. Serious disputes were drawn into royal jurisdiction. Authority became centralized, but law remained practical and case-based. In 1086, William ordered the Domesday Book, compiled at Winchester. It recorded land ownership, obligations, and value across England. From that moment, land disputes increasingly depended on royal records rather than memory. Law began to rely on documentation. Over the next century, the King's Court, the Curia Regis, expanded its reach. Royal officials judged disputes involving land, revenue, and loyalty. Local courts continued, but final authority increasingly lay with the crown. A decisive transformation occurred after 1154 under Henry II. Permanent royal courts were established at Westminster. Judges were sent on circuit throughout England. Standard writs allowed cases to be brought into royal courts. Judges were expected to decide cases consistently. In 1166, the Assize of Clarendon introduced juries of presentment. In 1176, the Assize of Northampton strengthened royal criminal justice. Trial by ordeal faded. Decisions were recorded. Judges began consulting earlier cases. Without any single declaration, precedent emerged. Similar cases were decided in similar ways. Law became common to the realm. By 1215, conflict between King John and his barons produced the Magna Carta at Runnymede. It affirmed lawful judgment and limited arbitrary punishment. Most importantly, it placed the king himself beneath the law. Across the following centuries, common law courts became professional and institutional. Judges, lawyers, and juries formed a stable legal culture. Case reports recorded reasoning. Law developed through accumulation. By the early 17th century, England possessed something unusual: a legal system with deep continuity, capable of limiting authority through precedent. That system was about to be tested to its limit. In 1625, Charles I became King of England. Charles believed strongly in the divine right of kings, the idea that monarchs derived authority directly from God and were answerable only to him. Parliament increasingly disagreed. Charles raised taxes without parliamentary consent. He imprisoned subjects without trial. He attempted to rule without Parliament altogether. These actions were not initially resisted through rebellion, but through law. Courts were asked to judge whether imprisonment without charge was lawful. Legal arguments relied on precedent. Judges examined whether royal power could override established legal process. In 1642, political conflict turned into civil war. What followed was unprecedented in European history. In 1649, King Charles I was put on trial, not assassinated, not deposed quietly, but formally charged. He was tried by a court, found guilty, and executed. This was not merely a political act, it was a legal and constitutional rupture. For the first time, a reigning monarch was judged by those he ruled. Yet what happened next is equally important. England did not descend into permanent chaos. The monarchy was abolished, and Oliver Cromwell emerged as the dominant figure. England became a commonwealth, later a protectorate. Cromwell ruled with immense authority. Parliament was dissolved and recalled. Military power was strong, and yet the common law courts continued to operate. Judges continued to hear cases. Property disputes, contracts, and civil claims were still resolved through precedent. Even in the absence of a king, law did not disappear. This revealed something critical: the legal system no longer depended on the monarch. After Cromwell's death, the experiment ended. In 1660, the monarchy was restored under Charles II. But this was not a return to the old order. Charles II ruled knowing what had happened to his father. The divine right of kings still existed as belief, but it was now contested. Power had been publicly separated. Conservatives continued to believe in divine authority and monarchy. Others accepted that sovereignty involved law, parliament, and consent. What emerged was not the destruction of divine belief, but its containment. The king ruled, but within limits. Law had proven that it could survive, judge, and even execute authority, and still continue. This balance was formalized further in 1689 with the Bill of Rights, which limited royal interference with courts and affirmed parliamentary authority. From this point on, power in Britain was no longer absolute. It was distributed. God remained above. Law stood beneath God. The king stood beneath law. The people were protected by process. This arrangement did not arise from theory. It arose from conflict, judgment, and precedent. By the 18th century, the common law had proven something rare. It could restrain power without destroying order. As Britain expanded overseas, this legal method travelled with it. Courts were established across continents. Judges applied precedent. Local bodies of common law developed. When independence came in the 20th century, many societies retained this system. Not because it was British, but because it worked. In Britain, industrialization brought new disputes. Courts adapted old principles to new realities. After 1945, statutes and human rights law expanded. The common law interpreted them. Today, judges still look backward before deciding forward. Power is reviewed through reasoning. Disputes are settled through process rather than force. The most important moment in this story was not the conquest of 1066, nor the reforms of Henry II alone. It was the moment when a king was tried, a monarch executed, authority questioned, and the law remained standing. That is when power truly shifted, not away from belief, but away from absoluteness. That is how the common law reached the modern world, and that is why it remains.